The topic for today's video is bills of lading, and in this video I'll be talking about what are bills of lading, what are the functions of bills of lading, the types of bills of lading, how does bill of lading differ from way bills and maid's receipt. We'll talk about signing of bills of lading and the problems encountered with bills of lading as well. Alright, so let's start with the functions of bills of lading. So bills of lading, the main functions are it's used as a receipt for goods received in vessel's custody. It is evidence of contract of carriage of the goods, and it's also a document of title. So a person who has the bills of lading basically holds the title to the cargo. It is the shipper's responsibility to provide the bill of lading. If vessel or the charter party has an approved format for a bills of lading, that is what should be preferably used. Normally two or more negotiable, with one or more non-negotiable, including captain's copy, is issued. All copies will be stamped copy non-negotiable, and master's copy is stamped accordingly, which clearly mentions that it's the master's copy of bills of lading. The other functions is that master may sign or agent may sign if permitted by the charter party. The bill of lading is based on the mate's receipt, and number of originals issued is mentioned on the bill of lading. A bill of lading is basically a contract between the carrier and the cargo carrier. Then we talk about the different types of bills of lading. So there is a clean bill of lading, which is said to be clean when it bears no superimposed clauses expressing declaring a defective condition of the goods or packaging. A foul bill of lading is one which is not clean in the above sense and is described as foul or unclean or closed. So that basically contains an expression which declares a defective condition of the goods. Receiver bill of lading is issued to a shipper when he or she delivers goods into the custody of the ship owner or the latter's agent before the carrying ship has arrived or is ready to receive the goods. A shipped bill of lading is issued after the goods have been actually loaded onto the ship. If it has been previously been given, however, it must be surrendered in exchange for or converted into a shipped bill of lading. A direct bill of lading covering the carriage of goods in one ship direct from one port to the another. Then we have an open bill of lading which gives no indication whatsoever of whom the goods are consigned to. A holder presenting an open bill of lading should or would be entitled to take the delivery of goods but would have no right to hold them against the rightful owner. A straight bill of lading is issued solely in favor of named consignee. No holder of such bill other than the named consignee himself would be entitled to take the delivery of the goods. We have the bearer bill of lading, which makes goods deliverable to the bearer and does not require any kind of endorsement. The property passes by mere delivery. An outward bill of lading is one which is issued in respect of goods being exported from the country to a destination abroad, and in contrast the homeward bill of lading is one that is issued abroad to cover a shipment of goods being imported into the country. The majority of the bill of lading is the order type of bill of lading, which are negotiable documents. That is, one part of the set must be surrendered, duly endorsed in exchange for the goods or a delivery order. Endorsement may be effected by either first the blank endorsement, where the person to whose order the goods are made deliverable simply writes his name on the back of the bill, and special endorsement, which is endorsement to some named person or persons. Then we have the thorough bill of lading, which is used for multi-transport, which provides a evidence of a contract of carriage from one place to another in separate stages, of which at least one stage is sea transit, and by which the issuing sea carrier accepts responsibility for the sea carriage and acts agent for the shipper in arranging carriage from place of acceptance to the final place of delivery. It should be noted that more than one carriage is used, hence the term multi-transport, and that the issuer only accepts responsibility for his own segment of the carriage. He then casts himself in the role of agent as between the shipper and other carriers if the loss or damage was caused while in their hands. It is usual for the issuer of the bill of lading to agree, if it can't be proved where the goods were when the loss or damage occurred, it shall be deemed to have occurred at sea. and the carrier shall be liable. Sea carriers frequently undertake the responsibility of arranging thorough transit. For instance, a shipment consigned from London to Bangkok may be carried from London to Singapore and there transshipped for conveyance by the other vessel to Bangkok. Freight for the entire journey would be prepaid as the principal sea carrier to the principal sea carrier. Then we have the combined transport of bill of lading. This is a negotiable document which evidences a combined transport contract, the taking in charge of the goods described by the combined transport operator at a place of acceptance, and an undertaking by him to deliver the goods at a place of delivery against surrender of the document. In this case, the issuer accepts responsibility for the entire movement and acts as principal with respect to the shipper and other carriers. More than one type of carriage is generally involved. When the stage of transport where loss or damage occurred is known, the combined transport operator's liability to the shipper or consignee is decided by the International Convention of Domestic Law applicable, used for door-to-door transport. Alright, so in combined transport, of course, one person takes in charge of the whole carriage, whereas in thorough bill of lading, we have multiple transport and people only take responsibility for a particular section that is covered by. How does bill of lading differ from mail's receipt? Well, bill of lading is an evidence of contract of carriage, whereas mail's receipt is not. Bill of lading is also a proof of title of carriage of cargo. Mail's receipt is not. Bill of lading can be considered a legal document for international trade. Mail's receipt cannot be considered a legal document. Bill of ladings are endorsable, whereas mail's receipt are not. Bill of lading is signed only by the master or agent, but the mail's receipt can be signed by the duty officer, chief officer, or the master. And finally, bills of lading can be used by banks for cash release to the seller, whereas mail's receipts cannot be used as a basis for release of cash. Bill of Lading Act 1855 states that every consignee named in Bill of Lading shall have vested in him all rights of suit and subject to same liabilities as if contract in Bill of Lading was made with himself. Nothing shall prejudice or affect any right of stoppage in transit or any claim for freight against the original shipper or owner. Every bill of lading shall be conclusive proof of such shipment against master or other persons signing the same. So in comparison, what are waybills? Well, waybills are non-negotiable documents many liner companies issue instead of bill of lading. They are suitable for use when there is a possibility of documents arriving after the goods at the destination or when there is no payment required. It is not a document of title as goods can be delivered only on identity without proper documents. Waybills are also used in contract of affreightments. The waybill has names and address of shipper, consignee, carrier. It also carries details of goods including quantity, weight and marks as well as the declared value of the goods. Waybills is evidence of contract and receipt for goods as well. What are the precautions before signing of bill of lading? Well, the bill of lading, before you sign it, it should be in proper form. It could be the ship owner's form or the charter's prescribed form. It should be correctly dated with the date of shipment. The mail's receipt showing that goods are actually on board and the apparent order and condition of the goods and details of any shortage have been surrendered should be considered as well. Marginal clauses as required should be included, but only those which are really necessary and lawful. Bills of lading should also declare that the freight is prepayable and has been paid, and if the ship is under charter and that owner's right under the charter party are preserved. The name of the vessel, port of loading and discharge should also be mentioned in the bill of lading before you sign. The name of the shipper, consignee should also be mentioned, condition and quantity of cargo, additional under the time charter, date of relevant charter party, terms, conditions and exceptions as per charter party, and endorsement of demurrage at loading port if laid as a reversible should also be included in the bill of lading. Finally, in terms of signing of bills of lading, if master does not know the weight or quantity loaded, then the words weight and quantity unknown should be written alongside the figure. If ship figures vary with shore figures, make sure both are mentioned. If master knows only the apparent condition of the cargo, it should be marked accordingly. If goods are damaged and noticeable, then master should endorse it. The words weight, measure, quantity, condition, contents, and value unknown should be added. The word said to be when used alone affords no protection. But when used in conjunction with said by shipper to be or said by the shipper to contain points out that no verification has been made by the carrier. What are the problems experienced with bills of lading? Well, if no original bill of lading is available at discharge port, what do you do? Well, the unavailability of bill of lading at the discharge port is not the master's problem. It is the problem of the buyer or seller of cargo. However, master should never release cargo without citing the original bill of lading and comparing with his own copy. A letter of indemnity is not sufficient evidence to release cargo. If more than one person is demanding delivery where each person is holding an original bill of lading, what can you do? Well, this may be due to more than one set of original bill of lading in circulation, some of which are unauthorized under normal circumstances. The carrier is within rights to release cargo to the first party that approaches him with the original bill of lading. However, if more than one party approaches simultaneously, then the master should seek assistance throughout the P&I club and may discharge cargo into the custody of the port or the warehouse in the port where it will remain under the legal control of the master. Sometimes bills of lading are required to be signed clean. Ship staff should ensure then that damaged cargo is not loaded. Further, bill of lading may be signed as per charter party or as per shore quantity. Any major differences will then result in a claim. In these cases, ship must consult the P&I club and lodge protest. In these cases, procedure for cargo release is that notify the receiver to have original bill of lading produced before discharge commences, compare with ship's copy for verification, and do not discharge till verification done. If letter of indemnity is only produced, then you should not discharge the cargo. So cargo should be discharged only with the original copy of bill of lading. If there are more than 2 copies, then it can be released, but it will be under the custody of the port or the warehouse, but under the legal control of the master. So I hope this was a short enough video, good enough for you to understand what are bills of lading, the functions, the types, difference of bills of lading with mails receipt and waybills, what precautions to be taken when signing of bills of lading, and what could be some of the problems with uh, bills of lading. So let me know what you thought about this video, and I'll see you soon with my next video. Bye guys.